So we were just telling. We were chatting.
Oh, really? Company vehicles, possibly. Like, which town, that's the way. Yeah. Was it? I think, or-
If you're not getting
Okay, good morning, everyone. Welcome back to docket 220701. We're gonna have a continuation of our late file exhibit hearing today. And as discussed at the end of yesterday, we are gonna begin this morning with tracking our outstanding read-ins, please.
Thank you and good morning, commissioners. So we have 5 read-ins. We'd like to proceed with providing the answers. We're going to start first with read-in W, and that was directed to Ms. Zabo. It was the question asked by PURA staff as it relates to taxes tied to SERP. Ms. Zabo, can you please proceed to provide read-in W?
Sorry, I'm just navigating to my worksheet. Yes, so yesterday we were asked with regards to Schedule C 3.25 to address if there were any items in the Connecticut state tax provision that included items for which we were not seeking recovery. In particular, the SERP-related M1 adjustment on that schedule was brought to attention, and we have kept that M1 adjustment within the C 3.25 schedule, as well as the book-related SERP expenses that currently are within our revenue requirement.
Thank you.
The next read-in was read-in Y, and that was asked by the Office of Consumer Counsel. It was concerning late file 32, and it was a further question about software licenses, and that was directed to Ms. Texera. Could you please proceed to provide the response?
Yes, the primary difference between the Office 365 business and the enterprise, which is what AQUARION has purchased, is that the business licenses are used and shared for up to 300 users. So we have licenses that exceed that amount. Additionally, the enterprise license provide enhanced security features for protecting information from threats, including message encryption, device management, rights management, data loss prevention for emails and files. And so this helps us to ensure that we had advanced threat protection, understanding controls and how data travels to respond and combat cybersecurity threats, which is and supports our program on cybersecurity. Additionally, the Microsoft 365 E5 licenses for our IT workforce provides enhanced controls for Active Directory. For example, there's an admin center that will allow our IT group to administer the accounts for our employees. Identity and access management features, such as integration with our other systems for single sign-on. Compliance management, which is supports metadata and content labeling, and also advanced analytic capabilities.
Thank you very much, Ms. Texera. The next read-in we had was labeled as read-in Z, and it arose out of a discussion for late file 34, attachment 1, page 12, that asked for the percentage of employees who charge their time to the Massachusetts and New Hampshire affiliates. That was also directed to Ms. Texera. Please proceed.
Of that list, 6 employees charge their time to other entities.
I'm sorry, can I just clarify? When you say other entities other than AWCCT?
Yes, that was your question.
Yes, yeah, okay, I just want to make sure. So 6 of the 24?
Yes.
Okay, thank you.
The next read-in was read-in AA. That was also directed to Ms. Texera. We were asked to delineate the limitations on financial approvals from the Director of Corporate Communications as they relate to community support. So Ms. Texera, can you please proceed?
Yes. The charitable donations budget is reviewed and approved by the VP and the President during the annual business planning and budgeting process. The Director of Corporate Communications can approve donations under $1,000 without approval as long as he stays within the operating budget that he has been approved for during the business planning process.
Thank you very much, Ms. Texera. The last read-in that we have was marked as read-in BB. That was directed to Ms. Zabo, and it was a question involving numbers that appeared on QRRU 413 compared to a number provided in late file 1, attachment 1 in the range of approximately $3,000. Ms. Zabo, can you please proceed to provide the read-in?
Yes, the values reported in response to RRU 413 related to merger costs of $5,314,659 is the accurate amount. Accordingly, the Schedule C 3.13 of late file 1 will be revised to reflect that amount. In addition, a question was raised regarding allocation of non-utility costs. In EOE 76, the percentage of costs allocated to non-utility was quantified at 1.2%, which would equate to $63,776. That will also be reflected on worksheet C 3.13.
And Chairman and Commissioners, one additional administrative matter was at the end of yesterday's hearing, we were asked to make a proposal for the authority's consideration on when we could submit the various requests for written updates we received at yesterday's hearing. We'd like to submit the following for your consideration. We're asking that for the updates to late file 1 and 4, which are voluminous, we would receive no more than 2 business days, and that would be due at 4 p.m. on Monday, December 19th. For all other written requests we received yesterday, we asked for 1 business day, and so therefore those would be submitted no later than 4 p.m. tomorrow, December 16th.
Thank you very much. Does any party want to be heard on that proposal? All right. Let's tentatively accept that, and we can discuss if there's any adjustment needed if there are supplements today. All right, thank you very much. Are there any administrative matters from parties or interveners before we begin? All right, very good. So let's resume with cross-examination. I think I said we were going to backtrack to the operational efficiencies and cost savings, non-revenue water and conservation panel. I can't recall if we covered this yesterday, so I'm gonna go ahead and ask the parties who have reserved the right for this panel to confirm whether they have cross. Does authority staff have cross for the operational efficiencies, cost savings, non-revenue water and conservation panel? Okay. Oh, okay, no. Thank you. OCC Attorney Datras or Attorney Wheel? Thank you. Attorney Wright? Nope. Attorney Marshall, I don't see you on here, but I'll ask. No, okay, thank you. Mr. Parent? EOE? Okay, questions from the bench, Commissioner Karen?
No.
Thank you. Mr. Vice Chairman? Thank you. I think I mentioned this yesterday. I have 1 or 2, I believes for this panel. I guess I could have maybe customer experience, but I had a question on late file exhibit 41, please, which was asking about the non-communications expenditures from OCC 151. Mr. Ulrich I think this was you. Okay, so I see the narrative, and I just want to make sure I understand the narrative vis-a-vis the OCC 151 response, and I'm assuming I'm supposed to be looking at the supplement that was filed on December 5th. Is that correct?
Correct, yes.
Okay, so if I'm looking at the attachment 1 that was filed on December 5th, the non-communications expenditures associated with conservation, is that terminology used to refer to like outside services? So like on the capital projects tab, for example, column D refers to outside services contractor. That's what we mean by non-communications, like essentially everything in this tab.
Yeah, no, things that weren't related to communications.
Okay. The education consultant who did the conservation programming prior to the pandemic, is that something that the company proposes to resume moving forward?
We plan to resume it. We're just trying to establish the best program and plan for that, considering the new world we live in with regards to COVID and people not being allowed into the school systems. So we're working on a plan to continue that education, but we don't have that in place right now.
Okay, and thank you. So if the company were to resume that or any of the other aspects of this narrative response, which, well, let me ask that question first. Are there any other aspects of this narrative response that were suspended due to the pandemic? So you talk about your irrigation program, patrolling, demand management pilots. Was anything suspended because of the pandemic?
No,
Okay.
no other features of the program were suspended.
Okay, so all the features described here, with the exception of the caveat that Ms. Texier just talked about with the education consultant, does the company plan to continue those as part of your conservation offering?
That's correct. Yep.
Okay, so I'm trying to link this back to what the company's proposing moving forward for your conservation spending and specifically the cost recovery associated with it. So you're proposing a regulatory asset, that's correct, Ms. Sabo?
Yes, there's two components to the conservation program that are in the current application. There's both the recovery of the regulatory asset as well as a new annual expense related to the program.
Okay, and the regulatory asset you just referred to as the historical
Correct.
Okay, so the expense moving forward, is that in a new reg asset or that's part of your cost of service?
No, we've included that as a component of our operating and maintenance expense.
Okay. Does that proposal assume a constant expense level based on historic spending that did assume the continuation of the education consultant?
Yes, so what we had done was looked at the historical spend over the last 5 years. Took an average of the spend over that 5 years and used that number to include into a new operating expense in the revenue requirement.
Okay, and was that expense line item subject to inflation, an inflation adjustment?
Let me double check. I don't think it is, but
Okay.
I will confirm.
Thank you.
It is not part of the inflation adjustment.
Okay. Thank you.
It's reported separately on Schedule C 3.7.
Thank you. Okay. All right. Thank you. I think I had one question on LFE 42. Just give me a moment. Okay, Mr. Ulrich, are you the sponsor of LFE 42?
I am. Yep.
Okay. I just want to make sure that I understand what this study is being used for. So I think the prompt for the LFA exhibit was to provide a copy of the consultant study that attributes savings to the conservation program. So is it just to connect the dots to what was provided? It looks like what was provided was the final report that covers the time period of 2015 to 2018, and it's dated November 8th, 2019. Are we looking at the same thing?
Yep, that's it, correct.
Okay, so can you give me like an elevator pitch about what the methodology was here? Was it looking backwards at actual savings, or was it assigning deemed savings values to measures that were deployed during
So
that time?
this was looking backwards. So we had implemented, we had the drought in 2016. We implemented our restrictions starting in 2017. Amy Vickers, who's a nationally recognized consultant on this, really the leading expert on conservation nationwide. We asked her to come in and do an evaluation. So she looked at 15 through 18 to compare the differences before we implemented the restrictions versus after. And what she saw is that there were, noticeable, there were some savings everywhere just because the drought was a dry year, but the savings in the towns that we implemented were 50% larger than the towns we didn't implement the restrictions.
Okay, and did she, I didn't have time to read all 103 pages, and know that may be shocking, but did she subtract out or put any savings towards actions that are more like system facing that the company may have took during that time? So replacement of water mains that may have reduced unaccounted for water, for example, or was it just straight up
No,
prepared?
she looked at actual customer account usage going through their meter.
Okay,
by
on a per
customer.
meter basis. Okay. Very good. And I think we had a discussion during the evidentiary hearings about whether a potential study for like forward-looking savings was conducted. And I can't recall if you're offering this study for that same purpose, or if that was something different.
There was a study that was done prior to implementing it, and that was forward-looking. We thought this was the most appropriate report because it did look at what was going on prior to restrictions and after, and making an assessment of what the benefits were.
Okay.
And like I said, I'll speak. I feel very strongly. I think the program's been a successful program, and we're really very proud of the program, and we want to document the fact that we think it's a successful program that should continue.
Okay. Thank you. And the potential study that was forward-looking, I seem to recall, I think you said it was conducted in 2014, 2015.
It's 2014 or 2015. I don't remember off the top of my head.
Okay. And so you brought the same consultant back 4 or 5 years later and who did the retrospective analysis. It was the same consultant.
Correct.
Okay. And as part of her retrospective analysis, do you know whether she compared the results to her potential study?
I don't know the detail in there. I think she made rough assumptions and was satisfied that we were within the range that she anticipated the savings she anticipated with the things we implemented.
Okay. And do you recall the timeline associated with the potential study? Was it looking out 10 years, 5 years, 20 years?
I'm going to say on the order of 10. I don't remember.
All right, fair enough. All right, thank you. Those are my questions. So, Attorney Pace, do you have any redirect for this panel?
I have no redirect. Thank you.
Very good. Thank you, Mr. Ulrich. Okay, so let's move to our next panel. I believe we have the customer experience. Customer experience fee-free program and the low income rate. So first up, we have authority staff. Attorney Keenan, please.
Thank you, Chairman Gillette. Good morning to the panel. I just have a couple questions regarding late file exhibit 64, and so they'll be directed to Ms. Texera. So in late file exhibit 64, you provided information regarding the order in which the low income rate assistance program credit, a federal low-income housing assistance program payment, and a customer assistance program voucher would be applied to a bill if a customer receives all three. I would just like to walk you through the application of these payments using to a customer's bill using a hypothetical customer who has a total bill of $60 in a credit as a result of receiving a CAP voucher. So based on the response to late file exhibit 64, the company would first apply the 15% LIRAP credit to the hypothetical customer's total bill, which would result in a $9 credit, correct?
Yes,
Okay, and the company would then apply the customer's CAP credit to the remaining amount, which in this hypothetical is $51, correct?
50.
50.
$50,
Okay, thank you. And then my second question is, with respect to this, the CAP credit that's on the customer's account, what happens to that credit if they move or their account is closed because they move to another location in Connecticut or outside of Connecticut? Is it returned to the customer?
If that credit was not because the customer themselves had a credit, then the company would retain that credit and utilize it towards, other customers who would qualify.
Okay, and with this, what about if the credit was the result of a LIWOP, a federal LIWOP payment?
That's a good question. I think that I would have to understand what the rules are regarding the LIWOP program, specifically with regards to credits. I don't remember off the top of my head in this particular situation with a credit. So we would comply with the program rules in a case where the company has received a credit that did not, pay for water usage because the customer moved out.
Okay, thank you. That's all the questions I have.
Thank you. Okay, Attorney Wheel, please.
Thank you. Good morning. I have one question for Ms. Texera. It pertains to late file 74. I just was looking for clarification. So I see the response indicates that these walk-in facilities, as it turns out, only accept cash or checks. I just wanted to confirm, does that mean they also don't accept debit cards, EBT cards, any other form of payment other than cash or checks?
That is my understanding, yes.
Okay, and that's all the walk-in facilities
Yes.
that the company uses? Okay, thank you. That was my last question and my only question.
Thank you. All right, EOE is up, please.
Morning, Frank Algeri, DOE staff. Just a few questions for you. Start with late file exhibit 67. Our question in this late file exhibit was where and how the company discloses its definition of satisfactory credit. I know at the hearing on the 5th, you stated what that definition was. Can you answer this question right now? To your knowledge, does that definition of satisfactory credit appear in writing anywhere in a customer-facing notice, letter, or bill insert?
Not on a bill insert in writing. It is on our website. When a customer applies for that security deposit and the application, in that section before they click in there, that information is disclosed there.
I believe that was the attachment 1 to EOE 23.
Yeah, so before you click on to get to that attachment on the website, there's verbiage there
Okay, thank
that
you.
describes it.
Staying with this exhibit, the response, I just want to discuss a couple of points in there. In the response, the company states, if the customer has made consistent and timely payments for the past 12 months, AQUARION determines that the customer has established satisfactory credit and will return the customer's security deposit together with accrued interest. And that's pursuant to the regulations. So in regard to this statement, does AQUARION automatically return the security deposit and any accrued interest upon the demonstration of satisfactory credit?
We do not automatically do that from an administrative perspective. We will provide it if the customer calls or if the customer moves out. And we are working to automate our system to automatically do that moving forward.
Okay, so in your response, you said the usual procedure is to retain a security deposit until final discontinuance of the customer service.
That's been our administrative
Administrative,
practice, yes.
Right. And you're aware that by regulation, once satisfactory credit has been established, the security deposit shall be returned. If you're not aware, I can point out where it is in the regulation.
Yes, that is what the regulation says, according to what's in front of me, yes.
Okay. So linking back to my previous question about does the definition appear in writing? Based on that requirement, how is a customer with a security deposit to know that the deposit can be returned prior to the discontinuation of service?
Well, if a customer would like their amount applied to their outstanding balance, they're provided that information when through that website, through our website when they're applying for service. And if they call us, we will apply the credit to their account with interest. And we do calculate the interest on an annual basis and credit it to their account in order to keep the customer whole.
Is it possible that there are customers with security deposits that have demonstrated satisfactory credit prior to discontinuation of service and have not had that deposit refunded to them?
Yes, it's possible.
So this is a situation that's still occurring today.
Yes.
Leads me into the response to late filed exhibit 68. In your response, it states that AQUARION was not able to track the information that we requested. I'm just curious, does the company have the ability to track the number of customers that have achieved satisfactory credit and are still active customers today?
I would have to work with our collections manager to calculate the number of customers that have a deposit that have a satisfactory rating. I can try to read that in.
I would not need this as a
Okay.
read-in. Thank
Okay.
you. But you would have the ability to track the number of customers with security deposits that have achieved satisfactory credit.
Yeah,
are
I mean,
still
we can
active.
run who has a credit on, who has a security deposit on there, and then do some further analysis to determine if they have a satisfactory credit rating with us based on the criteria, the definition, to get to that number. And as I mentioned, we are working to program our system to handle this in an automated way moving forward.
Okay. Last set of questions, real quick. The response to late file exhibit 69, please. In the table, reason number 1, there's a number 834. Is that 834 meters or 834 meter readings?
800, well, it hopefully be the same, you know, the number of meters, 1 meter equals 1 read.
Okay.
So, yes, those are meter readings that don't pass the validation process.
So that doesn't necessarily mean there's 834 meters that haven't passed validation.
Well, I'm looking at this as if you're reading 1 meter and the read doesn't pass the validation for reason number 1, the periodic meter reading, it will be a 1-to-1 relationship.
So that can represent 834 separate meters.
Yes.
Okay. And in regard to that number, are all of these meters where there have been, are all of the reasons that these failed, is it because there have been 2 or more consecutive estimated meter readings?
It could be, yes. So some of the validations that we look for when it doesn't pass, it could be a 0 consumption. It could be the number of estimates have exceeded what's in our system. It could be it's too high, too low. There's a meter overflow. There was a previous implausible read on that account, which requires further investigation. So there are a number of criteria that we look at that our system is programmed to look at to account for those 834.
And that could include any meter with an automated meter reading device that doesn't transmit data to the company?
You mean like if a meter stopped?
No, meter keeps registering, but if it has a data transmitting element to it that sends the meter reading data to the
Yes,
company.
typically we wouldn't be able to get a read, you know, which means that nothing's coming over, which would prompt, you know, a notification to be created to investigate.
Thank you. That's all I have.
Thank you. Attorney Alexander?
Thank you. Just 2 follow-up questions on Mr. Ojiri's cross. Ms. Texera, you mentioned that you were automating the system to automatically return security deposits. What form would that refund take? Would it be bill credit, refund check? Does it depend on the customer's preference?
We would credit the customer's account.
Okay. And you also mentioned that for the accounts for which you hold a security deposit, that you credit interest on an annual basis. Could you explain what you meant by that statement?
We're required by regulation to apply interest to a deposit from a customer, and we credit those customers' accounts with the interest that's prescribed by that regulation. I
Okay,
believe it's 1.5%,
And does that happen on a monthly basis, on an annual basis, or?
an annual basis.
Okay. That's all I have.
Just have one
Thank you.
one question on a follow-up also. Do you have a projection of when that automated system or process might be up and running?
January, or testing the system right now
Okay,
to comply with that.
thanks. I mean the return of the security
Yes.
deposit system, just so we're clear. Thanks.
Okay. Thank you. Attorney Wright. And am I missing anyone on this panel? Nobody else is on this agenda. Okay. Okay. That leaves us questions from the bench for this panel. Commissioner Karen.
No questions.
Thank you, Mr. Vice Chairman. All right, thank you. Can we turn to late file exhibit 73, please? Okay, Ms. Texera. I appreciate very much the company's response here. I just want to make sure that I understand what is meant by the terminology bank fees and equipment fees in this reference. Are those speaking to whatever fees the company currently pays to a vendor for processing checks? Is that what those fees are? Okay.
Yes, that is.
Thank you. And the postage and the bill print, those are just for any customer who has not accepted an electronic bill at this point. Is
Correct.
that correct? Okay. So what is the difference between the top 4 fees that are attributed to company costs and then the ratepayer one-time payment processing costs?
So the company costs are the costs that the company pays for bill print, for postage, for accepting electronic payments from banks, from our lockbox, things like of that nature. And the 217,000 are costs that are incurred for the one-time payment that customers pay for themselves to make that one-time payment. Which we are requesting approval for in this proceeding.
Right. So, thank you. So the table that's embedded in this response is that, that's been revised to be all inclusive, or do I need to add this to the company's previous proposal about what would? Let me see if I can ask this in a clearer way. So the discussion that led to this late file exhibit was about the company putting certain types of costs into a tracker that would be reconciled if the fee-free program is approved, correct?
That's correct. So I think the way we presented the information previously was centered around the payments.
Right.
And not the total cost of providing bills and the postage related to those bills. And I think there was a request to include all the costs, and that's what's reflected here.
Okay.
Yep, just to add additional detail behind that, the initial application included a proposal that was really only addressing the 217,000 in terms of a tracker. And based on the conversation during the hearings, what we tried to capture in this response is that there are indeed other customer-related bill processing costs that we think would be appropriate to include all of them in a tracker. That way you get the full picture if people are changing their payment methodologies as a result of what we're looking to implement.
Thank you. Perfect. So this captures everything.
Correct.
There's nothing. Very good. Thank you. Okay, that was my question. Attorney Pace, any redirect for this panel?
Just a very brief moment to confer.
Sure.
Thank you. Thank you, Chairman. We have no redirect.
Very good. Thank you. Let's move to, okay, so apologies, we're gonna have to do a little bit of a shuffle here as we're gonna pull up the Office of Consumer Counsel's panel on the same topic. Okay, welcome back, Mr. Colton. I'll remind you that you remain under oath, and if your attorneys could have you adopt your late file exhibit, please.
Good afternoon, Mr. Colton. Did you sponsor late file exhibit 75 as filed in this proceeding?
I did.
Do you adopt that late file exhibit as part of your direct testimony in this case?
I do.
Thank you. With that, Mr. Colton's available for cross.
Thank you. So we'll begin with Attorney Keenan, please.
Thank you, Chairman Gillette. Good morning, Mr. Colton. I have a few questions regarding late file exhibit 75. And in that late file exhibit, you provided a number of dockets in which you recommended metrics or metrics and outcomes. So in your first example, which begins on page 2 and is regarding docket number R-2022-3031211, you recommended 3 metrics by which to measure Columbia Gas's actions and 3 outcome objectives, correct?
3 outcome objectives, yes.
What were the incentives or penalties associated with each of the 3 outcomes?
There were no incentives or penalties. There were no incentives or penalties.
In the second example, which begins on page 3 of LFE 75 and is regarding docket number R-2022-3031172, you proposed 7 metrics by which to measure Pennsylvania American Water Company's credit and collection activities affecting low-income customers. Using these metrics, you then concluded that Pennsylvania American did not merit an ROE enhancement. Is that correct?
Yes.
Do you see any reason why some or all of these metrics could not be tailored to adjust, for example, a company's executive compensation?
No. Let me make clear no, I see no reason why these could not be applied to executive compensation.
Thank you. And of all of the metrics and outcomes that you've recommended in late file exhibit 75, what are the top 3 that you would recommend for Aquarion and why?
Oh. Number 1 is I would recommend the same metric I recommended in a couple of cases here, which is the percentage of estimated low-income customers that have been identified as low-income customers. And the reason I would recommend that is because it is not possible to adequately serve low-income customers unless you identify who those customers are. So an absolute first step towards serving low-income customers is to identify them. Number 2 would be the percentage of the identified low-income customers who are enrolled in the low-income program, or given my direct testimony, in the low-income discount. One of the reasons to identify these low-income customers is to make sure that the company can serve the needs of those low-income customers. And the way to serve those needs, at least for Aquarion, as we are discussing in this proceeding, is through enrollment of those customers in the low-income discount. Number 3, included within that enrollment in the low-income discount would be enrolling customers in the low-income discount and maintaining that enrollment from year to year. So if you enroll X number of, let me just make up a number. If you enroll 10,000 customers, and that's a hypothetical number, 1 year, but you require a re-enrollment on an annual basis and you lose 4,000 of those customers during the re-enrollment process, then that would be wrapped into that second metric. You would want to enroll the customers and ensure that they remain enrolled from year to year. Number 3 is it is difficult to summarize in a single metric because the metric would be whether the enrollment in the low-income program is having a noticeable impact on the collections or on the payment patterns of the low-income customer. And as I talked about the last time I was here, the impact on the payment patterns would include whether payments were complete, were complete, whether payments were timely, whether payments were regular, and whether payments were what I call unsolicited, which isn't a good cover term. But what I mean by that is that the utility doesn't have to chase those payments with collection activities. So the third metric would really have those 4 sub-metrics. And there are specific measurable metrics that I discussed in this exhibit as ways to measure those. Those aren't abstract concepts. Those are measurable outcomes.
Okay, thank you. And do you have recommended incentives or penalties to attach to those outcomes?
I have not historically recommended incentives or penalties, except when my testimony has arisen in the context of a utility request for a kicker for exemplary management performance or superior management performance or some such thing. If the company has requested a 0.25% kicker or a 0.2% kicker on its return on equity, then if the metrics have not been adequately met, I've recommended that requested kicker be disapproved. So if you view that as a penalty, I've recommended that as a penalty. But as a general rule, I have my role has been to identify how and whether the utility has been adequately serving its low-income customers. And if the finding is that the utility has not been adequately serving its low-income customers, the question becomes what needs to be done differently in the future to make sure that the utility will adequately serve its low-income customers.
Okay, thank you. That's all the questions I have.
Thank you. Does the company have questions for this witness? No questions. Thank you. Attorney Wright. Does EOE have questions for this witness? No questions. Thank you. All right. Questions from the bench, Commissioner Karen?
No, no questions.
Okay. Thank you. Welcome back, Mr. Colton. I think Attorney Keenan has largely addressed my questions. But so she asked you for your top 3. might I ask you for maybe your fourth or your fifth recommendation? I know you've outlined a number in the response to the late file exhibit, but if I could draw on your expertise in this matter just a little bit more.
Yes, certainly number 4 would be to begin looking not, let me begin over. Number 4 would begin with the observation that the low-income customer base is not a homogeneous group of people, that there are subpopulations within the low-income population, and those subpopulations have different needs. So, for example, the population of customers with incomes at 0 to 50% of poverty, or with incomes at 0 to 100% of poverty, because of their lower income, have poorer payment patterns and have greater needs. So the question is not simply, are you enrolling a percentage of the low-income population as a whole, but are you enrolling proportionate percentages of people particularly at the lower income levels, because that's the population of customers. Those are the people who need the most help. If all you're doing is enrolling people at 150% to 200% of poverty, or 200% of poverty to 60% of state median income, you're only enrolling the people who need assistance the least. So that would be number 4. I didn't say that very elegantly, but hopefully you followed me.
I did.
Uh,
In that vein, and when you first said subpopulations within low-income groups, I went to renters versus homeowners, single family versus multifamily. Are those other examples of subpopulations with low income that have any merit to consideration?
Particularly in the water industry, serving tenants is really tough because tenants tend to strike that. Tenants are often not direct customers of the utility. So, for example, in this proceeding, nobody has proposed to provide a discount to tenants who aren't customers of the company because A, we don't know who those tenants are. B, we don't know what the water bill of those tenants are. C, the water bill is frequently an undesignated part of rent. And so there's no way to provide a percentage discount on the water bill. So serving tenants is a tough thing to do. I think that the way to address subpopulations other than those people who are at different incomes is to look at the extent to which people who have enrolled in other public assistance programs also have been enrolled in the utility assistance program. So if if a low-income household has taken the effort to enroll in Medicaid or to enroll in the free school lunch program there's a whole list of public assistance programs. To enroll in TANF, I don't know what TANF is called in, the temporary aid to needy families, whatever that program is called in Connecticut. If somebody is enrolled in one of those public assistance programs, it's reasonable to assume that if they had appropriate information and an adequate and appropriate mechanism through which to enroll in a utility assistance program, in an AQUARION assistance program, they would do so. It's reasonable to assume that they wouldn't choose to enroll in one program and choose not to enroll in a different program. So the metric would be the extent to which you are engaging in cross enrollment. And I think you pick up a lot of the subpopulations that you identified in your question.
Thank you. Thank you. Any other particular metric that you identified in late file exhibit 75 that you wanted to bring to our attention?
If you look at outcomes, there are a couple of outcomes that should flow from the metrics that I've already identified. For example, the percentage of, or the rate at which disconnections occur. And when I say rate, I mean the number of disconnections for identified low-income customers per 100 low-income customers. So if you've identified your customers, if you've enrolled those customers in your program, your rate of disconnection should decrease. The rate at which customers, both in terms of the number of customers and the dollars of bills of identified low-income customers are in arrears, should decline. So if you've identified your low-income customers appropriately, and if you've enrolled those customers in your program, those metrics should decline over time because you will have been meeting the needs of low-income customers. The rate at which deferred payment arrangements of identified low-income customers, and each of these metrics, I'm referring to the metric as applied to the identified low-income customer base. But the rate at which deferred payment arrangements for identified low-income customers succeed rather than default should increase. Because again, if you've identified your low-income customers and if you have adequately, if you're providing an appropriate discount, if and when they do enter into a payment plan, more of them should be able to succeed at that payment plan. So those are some of the metrics.
Thank you. So in each of these metrics, they have to refer to a baseline for which to compare to. Would you recommend, how would you recommend identifying the baseline? So, we saw a number of metrics in late file exhibit 75, and regrettably, it doesn't seem like a lot of utilities are tracking some of these metrics, so it might be difficult to pull together an industry baseline. So we're talking about a historic baseline from the specific utility, or how would you go about identifying that?
I think Connecticut is my impression is that Connecticut is at the point where you're talking about creating metrics on a going forward basis. So particularly in the water industry, if this were the electric industry, obviously PURA could use hardship customers as its definition of low income, and AQUARION doesn't have that baseline. So I think that you would need to give AQUARION a period of time to develop a baseline, because AQUARION hasn't identified its low income customers, even though it's had 5 years to do so, but it hasn't identified its low income customers. So you would begin with the identification of low income customers and the enrollment of those customers over the next 12 months. And then after that data collection has occurred, I think you start looking at the impacts of, or the outcomes of the enrollment on the collection metrics that I've talked about. But you don't have, certainly don't have a company specific, and I think you don't have a water industry specific baseline to work with at this point.
Right. There was, however, a study that I think you referred to about the percentage of income, household income that should go to water. We discussed that last hearing, correct?
Yes, and there are a couple of studies that support the 2% that I've recommended for water on a standalone basis. Recognizing that my 2% recommendation for water really ties together with 4% for combined water and wastewater and 6% for energy. All of those fit together. But there are a couple of studies that support my 2% affordability definition for water on a standalone basis.
Thank you. And just a moment ago, when you referred to that the company had 5 years to create a baseline but hasn't done so, can you just, I didn't quite understand that comment.
Oh, because the utility was directed in the acquisition decision to develop a low-income program to present in its next base rate proceeding that would best meet the needs of its low-income customers. And so given that directive, and given the fact that that directive was issued in 2017, the fact that we are now in 2022 and the utility doesn't know, still 5 years later, doesn't know who its low-income customers are and has not made the efforts to discover or to identify its low-income customers, and therefore to identify the needs of its low-income customers. We're 5 years after that acquisition order, and we're not even at step one yet. That was the nature of my observation.
Thank you very much. Those are my questions. So I'll ask your attorneys if you need a moment to consider redirect.
We do have some redirect.
Thank you.
And I believe we both have a couple of questions. I'll ask mine. Actually, following up on the question the chairman just asked you regarding your comment about Aquarion having not identified its low-income customers yet. In your experience, have you observed that a utility company taking the initiative to begin collecting that kind of data, or do companies generally have to be ordered to collect the data specifically by a regulatory body?
Well, I work in regulatory proceedings, so generally the issue when I'm involved presents itself as an issue to a regulatory commission, and the utility is directed to collect certain information.
Is it your understanding that there's anything about that directive, that kind of directive, that mechanically is necessary in order to start collecting that kind of information? In other words, are you aware of any barrier for a utility company to begin collecting that kind of information absent a directive from a regulatory body?
No, not at all. The utility, if I understand your question correctly, a commission directive or a pure directive to collect that information is not a necessary first step to a utility collecting that information.
Thank you. And actually also sort of related, I think, to the chairman's other question, or one of them, regarding the last metric you recommended when you were being crossed by Purist staff on payment patterns, the observations of the impact on payment patterns. Do you think that impact could be measured in part by tracking historical arrearage data prior to the implementation of a low-income discount rate as compared to arrearage data subsequent to the implementation of the rate?
Yes, that absolutely. That once the utility identifies a low-income customer, that utility would not be constrained to only look at information on a going forward basis. Of course, the utility could go back and request, meaning do an inquiry of their billing system to obtain historic data. Yes, and to that extent, my earlier response that the metrics could only be applied on a going forward basis, I would modify that.
Okay,
Yes,
so
of course, you could look at historic data.
okay, so for instance, after the implementation of a low-income discount program of any kind, would it be appropriate, in your opinion, for a utility to look at arrearages after some point of time, say a year or 2 years after that program were implemented, and then look back over the last 5 years of arrearages prior to the implementation and use a comparison between those kinds of metrics to determine, in part, to determine the effectiveness of the program?
Yes, and we would need to talk about what the appropriate historic period is, because of course, COVID falls within a backward-looking 5 years. And so it would be necessary to make sure that we're not looking at data that is skewed by COVID. So with that caveat, yes.
Okay, and you also mentioned shut-offs for non-payment. Same question for that. Would it be appropriate, in your opinion, for a company to look at historic data for the numbers of accounts that have been shut off for non-payment prior to the implementation of the program versus after, in order to determine some gauge of program success?
Yes,
Thank you. I think Attorney Datris has one or two.
with the same caveat about COVID.
Thank you.
Thank you, Mr. Colton. I have just a brief follow-up related to a term you used in response to a line of inquiry from Attorney Keenan. And so Attorney Keenan was talking to you about the impact on payment patterns, and you used a term that was in addition to the payment programs, or excuse me, the payment patterns of a customer being complete, there was timely, there was regular, and then you added a term called unsolicited, which you defined. And if I understood correctly, you defined an unsolicited payment pattern of a customer as not requiring collection activities. Is that an accurate summation of your testimony?
Yes. I've never been happy with the term unsolicited as a cover term, but unsolicited, of course, payments are always solicited. Unsolicited means that a payment is not chased, that the utility doesn't need to issue reminder notices and non-payment disconnect notices and engage in those collection activities.
Very good. So just to drill down a bit more on the unsolicited term, is the definition of it, does it rely on an objective standard, or is it idiosyncratic to a company and their particular collection practices?
No, there are at least two ways that unsolicited, as I've defined it, could and should be looked at. Number one is a before and after. Before people have entered into a a discount program or a bill assistance program, and then during their participation in a program. And I presented examples of such an analysis in my direct testimony from New York, New Jersey, and Pennsylvania. And then the second is what one is trying to do through providing bill payment assistance is to bring the performance of low-income customers as close to the performance of non-low-income customers as possible. And so that would be the second comparison.
So would it be fair to conclude that it's sort of a closed universe of payment practices within a company that would define unsolicited as opposed to one company compared to another?
Well, it depends on the purpose you're using your metrics for, but I think both. The first thing you would want to do is to look at how the program is operating, and that's closed within the company. But if you have two companies and one is performing substantially less well than the other, that's a legitimate inquiry as well. So I would say both, but you start with a closed company inquiry.
Okay, very good. Thank you, Mr. Colton. Nothing further from the OCC chair.
Thank you. Attorney Pace.
Can you hear me, Chairman?
Not really.
I'll ask Ms. Lewis. Is that better, Chairman? No?
Can you hear him? Okay, we can proceed.
Chairman, the reason why I rise is that an additional statement was made during the cross-examination and redirect that did not appear in the original late file exhibit. The late file exhibit 75 focused on recommendations by Mr. Colton as they relate to metrics for evaluating how a company is addressing the needs of its low-income customers. But during the course of the testimony, he also gave an opinion about whether or not the company was in compliance with an order involving low-income customers in the change of control proceeding. I'd like permission to conduct just some very brief cross-examination on that additional new testimony.
So OCC have a position on this?
I'd respond. I think that the OCC would agree if the company were asserting that that statement should be given the weight that the authority deems necessary, given essentially that it's a legal conclusion and outside of the scope of the late file itself. So OCC would agree if the company sought to strike just that statement from Mr. Colton's testimony in lieu of him being cross-examined on it.
And Chair, just to be specific, it's the testimony where the witness offered his opinion that the order in the authority's decision, and I'm just going to make clear for the record, I'm reading from page 26 of the final decision in docket 170630. That's where the authority said, AQUARION shall develop and propose in its next rate case a low-income program that could best benefit its customers in need. And the witness offered his opinion as to what he thought that encompassed, including tracking data on low-income customers. So if the proffer by OCC is to strike that, we find that to be acceptable.
Okay, we will strike it and parties can, since we're addressing a legal conclusion as to whether the company has satisfied a compliance order of a decision, that's certainly something that the company and all parties and interveners can address in their brief. And we will consider that specific statement stricken from the record.
Thank you.
I apologize. I would just ask to clarify, the offer was to strike only the legal conclusion, the question of whether this company is in compliance with that particular order, but not Mr. Colton's testimony regarding his opinion of the capacity of a company to collect data on its own accord, and that line of questioning. So in other words, the offer was to strike specifically any statement by Mr. Colton that Aquarion has, or regarding whether Aquarion has or has not met its compliance obligation with regard to that order.
Attorney Pacer, is that your understanding?
And just to be clear, the concern we have is nowhere in the order that I reference is require the company to engage in some of the activities that Mr. Colton was proposing. He's offering his view as to what he thinks the company should have done, but those actual words do not appear in the order. And so if we're striking from the record his conclusion that the company was required to do that under the order, then that would be an acceptable resolution from the company's perspective.
Okay. Attorney Wheeler, great. So moved. So we will strike the limited statement, which represented a legal conclusion as to whether the company is or is not in compliance with that order, and all other testimony remains.
Thank you to the OCC and thank you to the Chairman.
Thank you. Okay. With that, Mr. Colton, thank you for reappearing today, and you're excused. Thank you. Okay, let's reshuffle. We're going to move to our 8th panel. The cost of service study revenues, rate design, rate adjustment mechanisms, and Veolia water supply agreement panel. Here, appears. And we'll recall the company's witnesses for these late file exhibits. And it looks like Attorney Dichter is first up on the cross-examination. So I'll ask him to approach the attorney's table. All right, Attorney Pace, any administrative matters for this panel?
No administrative matters. Thank you.
Thank you. Then Attorney Dichter, you can proceed.
Thank you, Madam Chair. I do have an administrative matter on how best to proceed.
Okay.
We've had a discussion about the new cost of service methodology to allocate the resale rate for Veolia, but that actual methodology is not in the record, I don't believe. And so I'm asking that notice be taken of the petition attachments and decision in the case, which is 19 dash, Mr. Pace, do you recall offhand?
19/12/27.
Thank you.
Okay, Mr. Attorney Dichter, you're asking for the decision for administrative notice of the decision?
As well as the company's petition and attachments, because the attachment has the actual methodology set out in it. Attachment number 1 to their petition is the methodology that was ultimately approved by the commission.
Okay, so the authority is not required to take administrative notice of its own decisions. They are considered, we're able to reference to our own decisions freely, so that is not required. I will have to take under advisement. I need to look at the petition and attachment and see whether they are adequately referenced and appended to that decision so that they would be covered. But Attorney Pace, do you have a position on the request?
Could I have a moment to confer with Ms. Zabo?
Yes.
Thank you.
Thank you. Attorney Pace?
Thank you for the chance to consult. The reason why I consulted was, we of course have no objection for the reasons the chair mentioned to the actual decision coming in to the record. But when he asked to incorporate the application, my question to my client was, did the authority approve the original proposal as is in the application? Because what it really goes to is that the right methodology we should be looking at as the final one approved by the authority? What Attorney Vaughn explained to me during our discussion was that he believes that appended to the decision is the actual final methodology. And so if the goal is to make sure we get the final approved methodology into the record, we believe that appears in the decision issued by the authority as well as the attachments to that decision.
Thank you, Attorney Pace. I can confirm, looking at the decision myself, Appendix B is the current methodology and ACAM methodology. Attorney Dictor, with that,
With that, I
established-
would withdraw my request.
Okay, thank you. Then we can proceed.
Ms. Zabo, during the course of this proceedings, we've heard a number of parties make recommendations as to adjustments to the company's filing on cost of capital and other areas. My question to you is, looking at OCC Supplemental 1, based on the interim decision of the commission on those factors, are adjustments to your methodology required?
First, I'll address the one correction that we discussed during hearings to date, which are also the reason for the update to OCC 101, Attachment 1. And that was a correction to the allocation of SEAC. And so to that point, I do believe that this, the allocation would need to be adjusted. The impact to the revenue requirement is a reduction of $13,538 for the portion allocated to Veolia. With respect to the remainder of your question, that is something the company would do based on the direction of the authority.
Okay, so such as the capitalization factor would be updated based on the decision of the commission.
That would be my expectation, yes.
Okay. That is all I have.
That's all you have? Okay, thank you. Deep BET, please. Deep BETP, please, Attorney Marshall. Thank you.
Good morning. My name is Ashley Marshall, staff attorney with DEEP. And I also have with me Eric Annis, staff from DEEP, and he has some questions for Ms. Sabo.
Good morning. Good morning, commissioners. First, I'll start a question that I should have asked last time, but it undermines all the questions I have. And that is the cost of service model you guys used, and that it came up just previous questions. Does that include any kind of environmental cost from the use of water, so harm to the environment, similar to something like the social cost of carbon that we use often in electric rate? kind of making?
Not that I'm aware of.
That was the answer I expected, so thank you. So quickly, I want to follow up, and we're going to be looking at LFE 57. And again, one of the targets that DEEP is interested in addressing kind of the tiered rate is trying to make sure that we're charging a rate for kind of irrigation and really really into discretionary use. So with that, when in LFE 57, we asked you to give us the number of bills and amount used by month. Is it fair to say that if we looked at the different tiers and we see tiers losing number of bills in a few months, so in the kind of watering season of May through September, October, and other tiers increasing, is it a reasonable conclusion that we're likely seeing residential use for irrigation as a big cause of that shift?
Yes, I think that's reasonable, and you can see that in late file 57, attachment 1, really in the tier 1 consumption pattern as you go through the calendar year.
Right. So we're seeing in tier 1 a significant drop off in the watering season, and then you'll see in particular tier number 4 in both the way the tier setups in BETP2 and the tiers proposed by the company. Tier 4 is the biggest one, but we're seeing it also in tier 3, less so in tier 2. Is that?
That's correct. And I just want to just set the stage here too, because I know we had some discussions during the evidentiary hearing in terms of that bill count. And so what we've presented in late file 57, for example, is if you had a customer whose usage exceeded the tier 1 volumetric, it would show as one bill on the tier 2 line. But everybody's calculation in terms of what your bill is would proceed through tier 1. The first 5 CCF would be billed at that rate, and then the remainder gets billed at the tier 2 rate.
Thank you. Yes. So, and I saw some interrogatories and a series of questions from Pura on trying to reduce the number of tiers. Do you remember those questions and interrogatories?
Yes.
Okay. So one of the options I wanted to think through was if we're going to shrink the number of tiers, which is the best way to do that? That also targets the DEEP's goal of trying to really focus in on the discretionary irrigation usage. Do you have any opinions on kind of if we're using less than 4 tiers, a good way of thinking about it from what you had here, collapsing some of these tiers to address that issue?
I think if we were to propose a 3-tiered structure as opposed to the 4-tier, my preference would be to keep tier 1 intact and potentially combine the tiers 2 and 3. My only qualification on that is consideration of where the tier 1 level stops. So we've proposed it at 5 CCF. When we look at the consumption data provided in late file 57 by month, you can see that there are a few months, if we wanted to look at the median, like a winter month of January where the median is at 6. So perhaps it might be something to consider in terms of setting the tier 1 rate, tier 1 level at 6 CCF and combining tiers 2 and 3. I think that would be a consideration.
Sure, thank you. And that gets at when I was playing with these numbers, my favorite solution, which was looking at BETP2's proposal, where I say tier 4 starts a bit early. So from the company's perspective, it would be starting at I forget the cutoff, but it was more. I think it was 9 CCF is where tier 4 would start on BETP2, as opposed to I think it was 14 or 15 in the company's proposal.
So we had in our proposal, tier 2 was over 5 up to 9. Tier 3 was over 9 up to 20. And then in the BETP 2 proposal, it was modifying tier 3, which was capping it at 15 CCF, and then tier 4 was everything over 15 CCF.
Right, and then we discussed, thank you for correcting me, and I forgot a tier in there. The discussion we had just a second ago, if we collapsed the 2 into 3 and made that a 2, and then the 4 becomes 3, it would be what do you think would happen in terms of the shape of the number of bills in those tiers? Would that better target or not be as good a target compared to the company proposal?
Target in terms of trying to capture the summer month of discretionary use. If you combine tiers 2 and 3, I think what you'll see is a pattern that is consistent with the usage in tier 4, and that being that you'll have a leveling off in the winter months, a peak in the summer months. Because by doing that, what you're capturing is the folks that are in tier 1 in the non-irrigation periods who are slipping into those higher tiers during the summer. So I think to answer your question, you'll wind up with a bill pattern based on consumption that is, I think a close mirror to what you're seeing in tier 4.
Okay, so I guess my final question is the company would not oppose the kind of collapsing of 2 and 3 and having 4 set at the ETP 2. That is something that the company thinks is reasonable if we're going to go with 3 tiers.
That's correct. I wouldn't be opposed to structuring it in a 3-tier structure. What I would want to give consideration to is the pricing within those tiers. So the proposal that we had in the 4th tier was targeting that one at the discretionary use, and we had established a price that was 20% greater than the tier prior to it. When we look at the tier 2 under our proposal, we had only suggested a 10% increase over tier 1, and we were looking at that in the context of how it compared to a single volumetric rate. And we found that tier 2 consumption, the rate we proposed, was pretty much right on with what a single volumetric rate would have been. So I guess I would be curious as to what the mindset is in a combined tier 2 and tier 3. How much of a penalty would be assigned in that pricing? Would we be looking to also suggest something, as big of a jump as a 20% increase from tier 1? That I think might be a little too aggressive, mainly because there still could be, some folks that are in tier 2 on the winter months that, are going to be feeling that pain, and it might not be discretionary use. So just something to consider in terms of where we put those price points. And then also in that consideration would be, as we move towards rate equalization across all of our divisions, we were taking some care to try and limit the impact by division, to limit it so it was no more than 2.5 times the overall request. So there's a lot of math that would have to be played out that I'm not prepared to do while I'm sitting here.
No, I appreciate it, and getting the concerns out on the record is what I would like to achieve. So I guess thinking along those lines, having tier 2 be that if we combine 2 and 3 and having that be the smaller jump that you have currently would keep that concern addressed, because you had proposed expanding that by one CCF as well. So you're going to get that piece, and then having the bigger jump to the tier 3, whether it's the 20 plus 20 again is the question, right? But that would address your concern, though, of not picking up the discretionary usage.
I'll play back what I think I heard. So if we were to go to a three-tiered structure, expand tier 1 to be at up to 6 CCF as opposed to the 5, price the tier 2 and 3 such that it's higher, obviously, than tier 1, but not necessarily a 20% penalty. We had priced it at 10. maybe that's the right mix, maybe it's 12. And then again, that new third tier would be priced at a 20% premium to whatever the settled rate is for the newly combined tier 2.
That's exactly right. And that would generally address your concerns of getting a kind of the non-discretionary use and vulnerable populations getting hit with the bigger jump, correct?
Correct.
Okay, thank you very much. I think those are all my questions.
I don't have any questions. That's all we have. Thank you.
Thank you. Does attorney staff, does authority staff have any questions for this panel? No. No, thank you. Attorney Datras or Attorney Wheel?
No question.
Thanks. Attorney Wright? Attorney Sherry? Okay, thank you. Commissioner Karen?
No questions.
Mr. Vice Chairman? I also don't have any questions. Thank you. Attorney Pace, do you need a moment to consider redirect?
No redirect.
Thank you. Okay, I believe we have one more panel left. All right. Let me take folks' temperature. Do we want, I can take a 5-minute break, call up the last panel, and then try to get through our administrative matters and break, or I can go to this, take a lunch break, come back. Any preferences? The 5.
We have no preferences, whatever works for the commissioners.
Okay, then let's do this. Let's take a 5, it's 11:38. Let's break till 11:45, and then see if we can come back, do this panel and wrap up administrative matters before lunch. All right.
Yeah, you too. Thank you.
Yeah.
You follow that process.
I was reading something. All these cases going on, I look up old decisions and stuff. I was getting a kick out of fixture counts, but no. Oh, yeah. I don't know. I think what's probably what's his name. Well, it was like what it is. So much per cell.
Yeah.
It's nice, but I was really. Your sales are off. Get growth, remember, we had growth, how many more customers? Now you have to calculate all the annualized customers that came in the rate, yeah. That was all your stuff, Jimmy. Mr. Revenue Man. Oh, man. I actually went to lunch with her. On Christmas, no. I ate breakfast, actually. She had a friend who had a. They put a solar. She was asking about different stuff. So I ran some numbers for her and told her how much the person was saving. And that was before the right around increase in GST was going to be announced. I said, well. Right, with the leases. Yeah, 3%. That's exactly right. They have a base rate and you can go up to 3%.
What they do with this increase here compared to the base rate.
It's in the winter clause.
No, if you're signing it now.
Right,
If you were
right.
before, but now.
They all of a sudden jump in. Yeah, exactly. Then next year the rate goes down. The rate goes down, you pay more.
Yeah.
That would be too, that would be. No, that would be too, we'll be getting a ton of calls. We get some. Just. It's a protection thing. That's one of the things where I think. Not having somewhere in charge. I sort of like. We're all going to hold on something. Uncle Albert?
Yeah.
What? That's what I was thinking about. Sorry, Uncle Albert.
Thank you, please be seated. Okay. Let's turn to our final panel, the cost of capital panel, and I believe EOE is first up for cross on this panel. So, Mr. Parent, please. And Attorney Pace, no administrative matters, correct?
No administrative matters.
Thank you. Then EOE, please.
Chris Parent from EOE. My question is on late file exhibit 76, and knowing that we're the last to go before we handle all the administrative matters and lunch, I'm promising to keep this very quick. So reviewing the late file exhibit, I just want to confirm my understanding of what was provided. The exhibit demonstrates that maintaining all variables such as rate base, return on equity, utility operating income, that an increase in the equity ratio would result in an increase in the customer credit. That's correct?
That's correct.
Thank you. Looking at the exhibit, I now understood a little bit of the confusion that was imposed last week, so I will pose my follow-up question to that. So carrying the concept further, if rate base and utility operating income were to remain constant, what would that do to the equity ratio? Would the return on equity increase or decrease under that specific circumstance?
Okay. I'm glad you asked that question because I had the same conclusion after this was submitted. So if we were to keep those variables constant, recompute an ROE, the resultant ROE would be 9.95% in this example. And again, this was using the same 54% from the submission, in which case that would result in a lower return to the customers.
Okay, so all else equal, ROE would be lower for what was a lower ROE and lower return to customer, if I caught that correctly. Okay. With each of the other variables constant and there being a decrease in the return on equity, I'm sorry, you just answered that. So there would be less of a credit to the customers. My final question that I jotted down here is in your broader response, you actually referenced Connecticut statute 1619G, and you quoted in here, and I'll quote this, specifically Connecticut General Statute 1619 subsection G requires that the actual earned ROE must be greater than 1%, 100 basis points above the allowed ROE for a period of 6 consecutive months. And it basically goes on to say that the over-earning would then result in an authority review. I just want to confirm the same premise as to what I was questioning as it relates to the earnings sharing mechanism that would hold true for the WICA filing. So if the equity position was to be higher than what was authorized, that would result in a lower ROE and ultimately could result in that statute not being applicable. Is that what your response is saying?
Yes, and what I was trying to highlight in this response is that the company's calculation of its ROEs has historically been reviewed under the context of our semi-annual WICA filings.
Okay, thank you. That is actually all I have.
Thank you. Attorney Sherrick? No? Thank you. Does attorney staff have cross for this panel? No. Attorney Marshall? Thank you. Attorney Datras, Attorney Will? No cross, thank you. Thank you. Attorney Wright? Commissioner Karen?
No.
Mr. Reister?
No cross, thank you.
I don't either. Thank you. Any redirect?
No redirect.
Okay, thank you. All right, then I think the witnesses and you're excused. And while the witnesses are leaving, if I could have any attorneys who wish to be heard on the motion that I flagged yesterday, if I could have any attorneys who wish to be heard on that, approach Mike at one of the tables. So we'll have a couple mics here, there. We can pause for a moment to get folks situated. So I will assume that if an attorney does not approach the mic, that your party or intervener does not have a position on the motion. Okay. Last call for anyone who wants to be heard on the motion. Otherwise, we're gonna start. So I don't believe the proponent of the motion is here today, so we will take the motion as their position at this time. So I will defer first to the company for their position on the motion, please.
Thank you, Commissioners, for the chance to be able to respond to motion number 38 that was filed by Smart Water Westport on December 14th. The motion asked the authority to take some very extraordinary measures in terms of scheduling another hearing no earlier than January 16th of 2023, plus an additional late file hearing at some point later in January. In our view, that upends the entire rate case schedule that everyone in this room here today has been working so hard to make sure that we respect and we follow. Because the relief is so extraordinary and because it has a substantial impact on the schedule, PURA should deny the request for the following reasons. First, we're not re-arguing PURA's decision to grant intervenor status to Smart Water, but it's important to understand some important context about what was given when they were given the chance to intervene. There's no legal entity registered with the Secretary of State called Smart Water of Westport. Instead, it's a petition to intervene comprised of 3 AQUARION residential ratepayers, plus one of those ratepayer spouses who do not like a water tank the company constructed in Westport. I mention this only because 3 residential customers received considerable latitude already by the authority by being given intervenor status. Typically, a standard approach would be to allow them to submit public comment and no more. Again, I'm not re-arguing that point, but just giving context. Second, it's important to look at the words the authority used when you granted intervenor status in your ruling on motion number 12 that allowed Smart Water to intervene in this case. Your ruling said, and it was issued on September 29th of 2022, it said, and I quote, "The authority declines at this juncture to exercise discretion under General Statute 4-177 AD to circumscribe Smart Water's participation in this proceeding. Although the authority cautions Smart Water, as well as all parties and interveners, that PURA retains the ability, if the orderly conduct of the proceeding is impaired." You then went on to say, and I quote, "Smart Water will be expected to abide by the orders, rules, and regulations governing this proceeding," end quote. My third point is the fact that the authority granted intervenor status and not party status is very important to examining, can the authority deny their request to cross-examine 2 times in late January? And by statute, the authority is allowed to deny the right to cross-examination to an intervenor. General Statute 4-177A, subsection D says, the authority defines the scope of an intervenor's participation. It also says the authority can elect to limit or actually prevent cross-examination if you conclude that the request would impair the orderly conduct of the proceedings. In our view, Smart Water's request would substantially impair the proceeding for the following reasons. Under the current schedule, briefs are due on December 30th. The draft decision, February 16th. The final decision, March 15th. The statutory deadline for this case ends on March 17th. Smart Water is asking for a hearing more than a month from now, plus an additional hearing at the end of January. That would be about 2 weeks before the current draft decision is scheduled to be issued. I don't see how we can realistically incorporate that in light of the timeframes we have in front of us. Fourth, Smart Water's motion number 38 provides no explanation as to why it seeks this type of relief in this rate case schedule. But based on the chairman's questions to me at the December 6th hearing, I suspect Smart Water's view is they need more time to review our interrogatories, and they also think we were not providing the information in a timely manner. So for my 5th point, let's actually focus on the interrogatories they issued to us and what the corresponding deadlines were in the procedural schedule. The procedural schedule says rolling discovery ends November 14th, which means all discovery had to be issued by the company to the company 14 days earlier on November 1st. Where does that 2-week period come from? It comes from the authority's revised notice, which says, and I quote, "Parties and interveners should provide at least 2 weeks to respond to any interrogatories," close quote. And the due date for any interrogatory responses, open quote, may not extend past the date published by the authority for the close of rolling discovery. So what that means was the authority was very clear to all parties and interveners. The deadline for rolling discovery ends November 14th. Questions need to be issued 14 days before that on November 1st. So when did Smartwater issue its questions and when did we respond? Smartwater issued its first set of questions on October 11th. We timely responded 14 days later on October 25th. Our first set provided a total of 44 pages of information. Smartwater issued their second set on November 4th, which was 3 days after the November 1st deadline for issuing discovery. They only gave us 10 days to respond, not the 14 days, but we responded and met that aggressive deadline. We provided 75 pages of information in response to set 2 on November 14th. Then Smartwater issued its third set on November 22nd. Why is that date important? That was actually the first hearing day. So when we were sitting here in this hearing room, the third set rolled in. That was 21 days after the authority said was the deadline to issue discovery questions. So the third set was issued 3 weeks late, and therefore we informed Smartwater we were not responding because the questions were issued late. But at the December 6th hearing, the chairman asked me the question, did the company respond to the prior discovery in an appropriate way? Was it timely and was it complete? And what I said at that hearing was I'd have my client look at the issue in good faith and make an effort to respond to those questions. So even though the questions were late in the third set, we examined them and we continued to show good faith by providing responses in a very short time frame on the due date for late file exhibits, and that was Monday, December 12th. My sixth point is Smartwater should not be allowed to cross-examine on any data responses filed in sets 1 and 2 because those data responses were timely filed before the deadline for rolling discovery, and that was November 14th. Consistent with PURA's prior ruling, Smartwater has to follow the rules. Smartwater could have showed up at any of the 7 hearing days that the authority had between November 22nd and December 6th to ask us questions about sets 1 and sets 2. But they decided not to show up. If you allow Smartwater to cross-examine on the data responses in sets 1 and 2, what you're saying is there's one set of rules for all the other parties and interveners and a special set of rules just for Smartwater. But that can't be the case because you told Smartwater in your approval of their motion to intervene, they have to follow the same rules that apply to everyone sitting in this room today. So that leaves us with the third set of interrogatories. And the question was, should they be allowed cross-examination on the third set of interrogatories? As I said before, those were issued 3 weeks late, long after the deadline. That alone provides the authority with a basis to deny cross-examination. But to the extent that Smartwater claims it wanted more information, the standard practice would be for a party to actually show up during the first 7 hearing days and raise its concerns with the authority and ask for permission for late files to be issued. All the other parties follow those rules. We were asked to produce 76 late file exhibits in response to questions by other parties and interveners. Smartwater had the right to show up and ask its questions. It failed to do that. Next, and most importantly, Smartwater's claim that its third set of questions, basically, in my view, after looking at them very carefully, there's no support for their claim that we failed to provide sufficient information. When you look at the actual questions they issued to us in that third set, they're new questions and they're seeking clarification on prior data that's been provided. In the interest of time, I'm not going to go through every one of them, but I think it's important to hear just a few examples. I'm going to start first with Smart Water question 17 that was issued in set 2. And the question was, when, where, and at what cost did the company run TV spots for fire protection community ads? The response the company provided on November 14th was, the company's 2018 conservation TV spot ran during the summer months, June to September, on Comcast and Altice cable networks. These spots reached Fairfield County and the Simsbury-Litchfield area. Refer also to response to EOE 66. In set 3, they claimed we didn't respond to that question. But what I just said demonstrates we did fully respond to the question. But what also appears in set 3 and question SW29 is Smart Water's adding brand new questions that never appeared in the prior set. So for example, they said, reply to the company's response to Southwest 17A, which I just read. And in the course of doing that, we want more information. The new question is, did AQUARION run fire protection TV spots during the 2018 Olympic Games? I'm not going to go through every one of these, but in responding to set 3, we identified for each and every question where in the record we had responded to it in either set 1 or in set 2 or in responding to someone else's questions. The next point I'd like to make on set 3 is that even if the authority thinks that we were slow in responding to the set, we submitted those responses by December 12th. Why is that date important? Because that was the deadline for late file exhibits. And so we submitted all of our late file exhibits by that date also. And the authority standing instructions were if any party wants to ask questions about late file exhibits or supplemental responses, you're to show up on the 14th and 15th and ask those questions. Every other party complied with the authority's directives. They reviewed the materials that were either late file exhibits or supplemental responses, and they showed up and they asked questions yesterday and today. Smart Water had the chance to show up yesterday or today. They once again failed to do so. My next point is that Smart Water's request will cause substantial prejudice to the company. As the authority knows, there's a statutory deadline to issue a final decision by March 17th, and their request to conduct these hearings will jeopardize that schedule. As the authority knows, these rates are non-reconciling rates and they're set prospectively. A delay in the case means a financial impact to the company. My 9th point is that the genesis of Smart Water's concerns are its concerns about a water tank that was constructed in Westport. And the authority has already reopened the docket 17-10-34 REO 1 to look at those concerns. Discovery remains open until March of 2023. There's ample opportunity in that contested docket to explore issues involving the water tanks. My next point is that PURA's denial of Smart Water's request still provides them with an opportunity to meaningfully participate in the remainder of the case. While they should not receive cross-examination in late January, they have the right to file a brief on December 30th. They can elect to submit written exceptions to the authority's draft decision, and they can elect to participate in oral argument, well beyond what a typical residential customer receives when they're only given a chance to offer public comment. My final point is that the authority shows a great deal of respect for process and procedure, and we believe that there should not be two sets of rules. And the authority and all the participants, we think, worked very hard in this proceeding to comply with those rules. And therefore, we think it's appropriate that you hold them accountable to the same sets of rules. So I hope these points were helpful. I appreciate the latitude and happy to take any questions. Thank you.
Thank you very much, Attorney Pace, and I will allow Attorney Wheel to respond. I have one quick question, Attorney Pace. The 3 sets of interrogatories that have been levied and responded to that you're referring to, would the company object to submitting those interrogatory responses into 1710-34 REO 1, or having the authority to take administrative notice there.
And just to be clear and make sure I'm responsive to the question is not to expand the scope of that case, but it would just be to simply take administrative notice of that evidence in the record.
I think so. I'm responding to, I can't remember if it's your 8th or 9th point, but one of the final points, in which I thought I understood you to be characterizing Smart Water's interrogatories as largely revolving around the subject matter of 1710-34 REO 1. So in response to that, I'm asking, does that mean that the company would have no objection to taking administrative notice of those 3 sets of interrogatories and the responses in that separate docket?
We would have no objection as long as it's clear, though, that it's not a concession by the company to expand the scope of that proceeding, which the authority outlined in its decision to reopen. And I'll give a for example. So to the extent, for example, Smart Water is seeking to disallow amounts and rates related to advertising or conservation, we do not believe that rates can be litigated in that proceeding. That would be an examination of the company's, implementation and construction of the Westport tanks and its compliance with the relevant permit being looked at. But it would not be an opportunity to now relitigate the rates that are being decided in this proceeding.
Understood. Thank you. So with that caveat, no objection.
With that caveat, we have no objection.
Thank you. Do my colleagues have questions before we turn to Attorney Wheel? Attorney Wheel?
Thank you. Excuse me. Should have coughed before I turned the microphone on. OCC's statutory mission is to advocate for the interests of consumers, but as the authority knows, that's a more complex mission than it sounds because not all consumers share the same interests. The Consumer Council puts a lot of thought into arriving at positions that best align with our mission, even where those positions sometimes are disagreeable to some consumers. The Consumer Council sometimes has to make tough choices about how best to advocate for outcomes that will provide universal benefits. Because of these realities, OCC cannot appear on behalf of individual consumers or consumer groups, and generally can't advocate for the specific interests raised by such groups, particularly where those specific interests may conflict with other consumer interests. All that said, it is our position that individuals or groups with targeted interests should be afforded the opportunity to advocate for those interests because equitable access, agency, and transparency are universal consumer benefits for which we advocate. For those reasons, we support Smart Water's motion. The authority has allowed Smart Water's motion for intervener status, thereby conveying to them certain rights to participate in this proceeding, including the rights to engage in discovery and to cross-examine. As noted in Smart Water's motion to intervene and Pura's ruling on it, Smart Water is not represented by counsel in this proceeding, and it's generally not inappropriate for courts and administrative bodies to grant certain leniencies to pro se litigants who don't benefit from the knowledge or expertise necessary to navigate procedural rules, regulations, precedent, or common practices. I'll also note that while there are some legislative mandates governing rate case procedure, as Attorney Pace referenced, such as the 360-day requirement for the final decision in this case, Pura maintains discretion in setting the procedural schedule within those confines, so long as its discretion is exercised reasonably. And combining those two thoughts, it was not unreasonable for Pura to consider. It was not unreasonable for Pura to order AQUARION to respond to Smart Water's interrogatories, even those issued after the rolling discovery period, in the spirit of leniency afforded to a pro se intervener and ensuring equitable access and promoting public participation. For the same, now that those responses have been filed and Smart Water is requesting the opportunity to cross, it seems to me the authority has two options. It can either deny Smart Water's motion and strike the interrogatory responses from the record as they wouldn't have been subject to cross-examination and cross, as noted by the UAPA, specifically for Section 4178, subsection 5, is required for a full and true disclosure of the facts. This outcome would prejudice Smart Water's ability to fully participate in this proceeding. The authority could also allow the motion, hold a hearing, and allow Smart Water and other participants, including the company, to elicit either cross or direct testimony to ensure that the record is as full and true as possible. The company has argued that this outcome would prejudice it, and I, of course, defer to the authority's judgment in balancing whether such prejudice exists. But I suggest that it doesn't outweigh the prejudice to a pro se intervener who has clearly been engaging in efforts to meaningfully participate in this docket. The OCC therefore recommends that the motion be allowed. We're further recommending that the hearing to allow for cross on these interrogatories be limited in scope to these interrogatories only, and that the record as to all other issues be closed, either at the end of this late file hearing or subject to the rulings made today pertaining to the supplemental exhibits still remaining to be filed. Lastly, we'd recommend that the deadline for briefs be adjusted to account for the schedule change and to allow participants to brief any issues that arise. And I'm happy to take any questions.
I just, in all due respect, they have not participated. I mean, the fact that Attorney Pace put forward here this afternoon was that they have been given the opportunity and have not. Quite frankly, we have not discussed it. I like the chair's idea of incorporating the interrogatories into 171034 and giving them their due process. I've been intimately involved with this water tank since day one. We have bent over backwards to accommodate these individuals, and I think we're still trying to do the same thing. But it's not fair to the company. We want to be fair to the people in Westport that they have their day too. But again, action speaks louder than words, and we've not seen them here. So that's what I'd like to say.
Thank you. Attorney Pace, any response?
Thank you again for the opportunity to offer just some very brief rebuttal. I think that the chairman offered a very eloquent solution to this issue, which is I understand that you're dealing with a pro se and the authority wants to ensure that you take reasonable steps. But the option that the chairman offered, in my view, is a very reasonable solution because it recognizes that the heart of their concerns relate to the water tanks, and that is a contested case proceeding. If the evidence is incorporated into the record and discovery continues through March of 2023, it's very difficult to see what the prejudice would be. And the company did adopt all of its interrogatories under oath, and therefore they continue to be able to have the ability to argue in their brief in this proceeding or in written exceptions or at oral argument, whatever their concerns may be. And the authority then can take those views into consideration in issuing their final decision in this proceeding. And I'll end by just stating that this authority has made very clear to all of us, all the attorneys and the pro se's in this proceeding, it's important to follow the rules. And the rule of law is very important to this authority, and it is as it is to all of the participants here. We've demonstrated with our actions that we take that very seriously by coming on time every day, producing the information you've asked for, and the other parties have shown that respect too in terms of the work they've done to make sure they're prepared. They've come here with very good questions, and simply Smart Water has been given multiple opportunities but failed to avail itself of those opportunities. So we think it's very important to communicate to all participants, not only in this rate case, but future rate cases, the rules are there to be followed, especially when you're given ample opportunity to do so, and there should not be two sets of rules. There should not be one set of rules that applies to AQUARION, to the OCC, to EOE, to DEEP, and to the New York towns, and then a separate set of rules that applies to Smart Water, especially when they were put on notice at the very get-go. You have to follow the rules. And so we for those reasons, Chairman, we support the solution that you outlined. We think it's reasonable, and the authority should deny motion number 38's request for special treatment and essentially a delay of almost a month in the rate case proceeding with the additional hearings being requested.
Thank you, Attorney Pace. May I ask a clarifying question? You referred to the interrogatories as having been adopted and sworn by your witnesses. Is it your position that all of the interrogatories, including the ones that were filed by the late file exhibit date have been adopted by your witnesses?
Yes, and the reason why I say that is whenever I have my witnesses adopt interrogatories, I don't list every single one. I just simply ask them for each witness who comes up to the podium, who comes up to the table, have you sponsored data responses and have you sponsored late file exhibits in connection with the proceeding? And they simply say yes, then we proceed to have them adopt those under oath. But if the authority would like reassurance of that, I'm happy to bring up one of my witnesses who can provide that confirmation for the record.
I will accept your statement. Is it your position that those interrogatories were subject to cross at today and yesterday's hearings?
It is my view because if we think about the first two sets were filed by the 14th. The first hearing day was held on the 22nd. And so therefore, when the witnesses came up here, they were available for cross-examination on all information that had been filed up until that date. When I then produced my panel on the 14th, which was yesterday, they were subject to cross-examination, not only on the late file exhibits, but any additional data responses that were filed before the deadline for late file exhibits. And that was evidenced by the fact that during cross-examination yesterday, they were asked questions about supplemental data responses that had been filed by the company up through the deadline for late file exhibits, which was Monday, December 12th. And what it illustrates is all the parties knew what the deadlines were, and the Consumer Council, the EOE, DEEP, Pura staff came here prepared on the 14th and today to ask questions about all those materials. They followed the rules. And again, Smart Water is saying, we want special treatment. There should be a new separate set of rules for us. There's been no explanation as to why that's the case.
Okay, I appreciate that. Do my colleagues have any further questions for the OCC or for the company?
Madam Chair, if I could. Just more of a comment than a question. I just want to make the point that the authority recognizes the unsophisticated nature of the pro se participant, whether it's an intervener, party, whatever. When I used to preside over small cell deployment before the establishment of EOE, and they took it over, recognizing that that was their one day in court, that they could make their case. The authority made sure we bent over backwards to walk them through the process. But with rights come obligations and responsibilities, and one of those is showing up. When they showed up, we worked very hard with them so that they understood a very unfamiliar process, that they had to provide evidence that would weigh in their favor. And if they didn't, we had limited discretion on addressing those applications. They were all very, with only a couple of exceptions, and these were very passionate issues for them. They understood our process and were very willing and able participants once they saw how the process worked. So I want to make it clear that the authority does take per se participants very seriously and are very happy to work with them if they're willing to do the work themselves. Thank you, Madam Chairman.
If I could briefly respond to that, Commissioner, I appreciate that. And if it wasn't made clear in my prepared statement before, I did want to add that the record here has demonstrated that same treatment for pro se parties by virtue of the leniency granted for two sets of interrogatories that were filed beyond the deadline, and the leniency granted in what we're doing right now, that we're hearing a motion at the close of this hearing. So certainly didn't want to infer that the OCC doesn't appreciate that the authority has a long history of granting that very kind of leniency.
No offense taken.
Thank you. Anything further from our participating attorneys? Okay, I think we're going to take this motion under advisement so we can provide a written ruling. I do appreciate the company entertaining my question regarding the interrogatories, and I expect that we will address that in a written ruling as well. So with that, we'll take the motion under advisement. A written ruling will be distributed through the docket. Thank you. So don't go anywhere, Attorney Wheel. Let me ask if we can have attorneys from all the interveners and parties approach just the mics so we can do closing administrative matters. Please, just a representative from each party or intervener. No one wants to join you. Don't read anything into that. Okay, I appreciate it. So I have some housekeeping matters to address before we adjourn, but I want to request if any of the parties or interveners have administrative matters to put on the table before I cover ours. Okay, so we have a let me start here. Attorney Pace, there were no supplements requested today. So unless there is an objection by an attorney at the tables, we will proceed as the company proposed with the supplements to late files. Hopefully I can read my chicken scratch here. Let's see. Late files 19, 24, and 30, I believe the company proposes to submit by 4 p.m. tomorrow, December 16th. Correct?
Correct.
Thank you. And the supplements to late file 1 and 4 by 4 p.m. on December 19th, which is Monday.
Correct. Thank you.
Okay. With that, we have the evidentiary record was proposed to close today. So I will ask if there is an objection to extending the evidentiary record until Monday at 4 p.m. so that we can, by definition, include the supplements to 1 and 4.
No objection.
No objection.
Objection. Thank you. So we will move the evidentiary record to close on December 19th at 4 p.m. And that adjustment we will make in the external calendar. Okay, I recognize that we have a motion under advisement that requires a written ruling, but I will proceed with the reminders anyhow, which are that briefs are due on December 30th at noon. The proposed final decision is tentatively slated for February 16th. Written exceptions, the 24th of February, oral arguments, March 3rd, and we are targeting a final decision at our regular meeting on March 15th at 10 a.m. I will note that we have currently contemplated oral arguments by Zoom. If that changes and we decide to hold our oral arguments in person, at least 10 days notice will be provided and distributed through the docket. But at this time, we are contemplating oral arguments by Zoom. Are there any questions about the material that I just covered?
Chairman, just one comment just to conclude, and that is on behalf of my clients and myself, we just want to thank the authority for the work that it put in along with the staff and the other parties and interveners in this rate case. We understand that a rate case creates a tremendous amount of work for the authority and all the participants. So thank you to all of you for your time and your dedication, and we appreciate your contributions to the process. Thank you, Chairman.
Thank you, Attorney Pace. I appreciate those sentiments. I thank all of our parties and interveners, stakeholders, and everyone, all of our witnesses that participated in the hearings, and last call for anything. All right, in that case, we are adjourned. Thank you.
Yes. Finally, right?
All right, so I'm not going crazy. Yeah. For that water. Yeah, the cold, I use it to heat. I just use the hose. Yeah. Thank you. Thank you.
Oh, do you? The, yeah, no, I